Hey all, welcome to our video about professional issues as it relate to providing professional counseling from a systemic perspective. You got a little bit about this already in preparation for this video, and there are three key topics that I want to cover a little bit more depth as they relate to what you've read already. These topics are confidentiality, handling our responsibilities as it relate to being summoned or subpoenaed to court, and making decisions about whether or not you want to participate in insurance networks. So confidentiality, court, and claims are the way that I've kind of organized these, and I've organized them in order of the likelihood and prominence of these issues in professional practice. So let's tackle confidentiality first. Because without a doubt, every day of your professional life will be influenced by your responsibility to maintain your client's confidentiality, whether you're working with multiple or individual clients on presenting issues. And so, of course, I'm assuming that you're already familiar with our basic professional responsibilities to, first of all, protect health information as it is defined in HIPAA, but also what our mandated reporter responsibilities are, and of course that is related to our duty as clinicians to warn and protect. I'm not going to go into great detail about those things because I've covered it elsewhere, right? But I want to make sure that we clear up a few things related to who can expect confidentiality in a family or couples counseling setting, right? Because as you're probably aware by now, most of our professional ethical and legal guidelines are based on a Western medical model, which is very individualistic in its nature, right? And also addresses as its baseline people who are considered of the age of majority, which in 48 of the 50 United States, at this point, at the time of this recording, the age of majority is 18. I think in Mississippi it's 21, and in Nebraska it's 19. That may have changed by the time you're viewing this. Nonetheless, you get the point that generally when we're thinking about adults, we're thinking about people that are 18 and older. But when we're doing family counseling, we're often charged with working with people under the age of 18 and knowing kind of what they can expect from sort of legal protections of their confidentiality. So, who can expect that their health information is protected? Well, one good rule of thumb is that the identified client can expect that their information will be kept private, and who is in the room during sessions can reasonably expect that their information will be kept private. If a person is not in the room, they may not have a legal claim to be able to view the information that was discussed or what happened during that session. If a person is under the age of 18, then they have the reasonable expectation that their information will be kept private, except for the fact that their parents usually will also have a legal claim to review information in the sessions, whether they are present or not. Now, this of course comes to bear when you're working with couples who may want to meet with you individually or may talk to you on the telephone in between sessions and disclose something to you of a sensitive nature, right? And then if it is disclosed to you in an individual session, whether it be a phone call or in person, whatever the case may be, then we are bound, barring some mandated reporter responsibility, to keep that information private. This also comes to bear a little bit, especially when you're working with adolescents, because developmentally, adolescents are at a place where they are attempting to at least begin the process of differentiating and developing their own identity apart from their parents. And there are times in which it would be developmentally appropriate for their information to be kept private. And oftentimes I think you'll find when you're working in professional practice that parents are onto this, right? They recognize that their child has a reasonable expectation of privacy, even if legally they have the right to know what's going on at all times. So one of the ways that is really important to be able to handle this skillfully, these nuances skillfully, is to make sure that you have informed consent processes embedded in your sort of system for opening cases and beginning the work with your clients. Oftentimes, after discussing sort of the limits of confidentiality with new clients, I will go over a couple of things that are specific to whatever or whoever is involved in the work. So if it is work with couples, I will, and other clinicians will do this too, identify that my priority is to help the couple achieve their therapeutic goals. Part of that sometimes is recognizing when information is being leveraged. So what I'm getting at there is recognizing when I'm being pulled into a triangle, right, against perhaps the other member of the couple. And I state very clearly I'm not going to participate in triangulation against one or the other. However, that being said, a person has the right to disclose something to me, and I'm bound by law to keep it private. But what I will suggest is that if you share something with me that is of that is significant to the therapeutic process, and you share it with me in a private setting, I will not disclose what you shared with me. However, I will discuss with you the value of sharing it in a conjoined session, and I will support you in sharing it with your partner. And I will also provide guidance on the impact of keeping this secret upon the achievement of the therapeutic goals, right? If someone shares with you something in an individual session that is couples in nature or parenting in nature, and they insist on keeping it private, it runs the risk, potentially, of undermining the therapeutic goals, right? Classic examples of this are affairs and things of that nature. So one way that you can address this nuance is from the very beginning, naming. Sometimes people will share things with me individually that I am bound to keep private based on professional, ethical, and legal standards. If that happens, I will discuss with you the value of sharing it with your partner as it relates to your therapeutic goals, and I will support you in disclosing it and working on it with your partner. The odds are very good that if a person is sharing something with you in confidence, it is a manifestation of the problematic pattern that they've come to work on, and you can frame it as such and work with them perhaps on an individual level about what are some of the barriers or defenses that they have up that are preventing them from being more transparent with their partner, whether it be as parents or as a couple. I do something similar with adolescents. And I'm working with an adolescent in a first session. I typically will have the parents there, and I will talk openly with the adolescent about, you have a reasonable expectation of privacy at, let's say, 16 years old, and because you are in the process of becoming your own person, right? And there are things that are a part of your life that you may not want to share with your parents. And you may have a right to keep that private. It may be good for you to keep it private. If you do, however, share something with me that I think would be of therapeutic value for you to share with your parents, then I will talk to you about that, and I will support you as you discuss it with your parents. Of course, a harder line is drawn when issues related to mandated reporting come up, and there are fewer options available to the adolescent at that point. But when something is not of a mandated reporting nature, then there could be opportunities to, again, recognize that attempting to keep this private is a manifestation of the problematic pattern, and disclosing it could be a way of unbalancing the system or otherwise intervening in creating a more cooperative, collaborative, cohesive relationship pattern in the family. Now, there are issues oftentimes with custody, where you may have one sort of primary custodial parent. By that I mean that the child primarily lives with one parent, let's say 5 days a week, and then every other weekend maybe they visit the other parent. Whatever the custody arrangement may be, sometimes even if they're not necessarily in great conflict, there may be sort of custody hearings, and the information that comes up in session may be of interest to legal representatives. And so there's a couple things that you need to be aware of. Number one, if you are subpoenaed or court ordered to court, you have to go or risk being held in contempt. You also run the risk of volunteering this work unless from the very beginning you set or disclose in your informed consent process kind of what your rates are for going to court. And these rates must be out of pocket. Insurance is not going to participate in or reimburse for time you spend at court. So what I do and what I've shared with you through Blackboard sort of is a template of the document that I use that sort of lays this kind of thing out for parents who are in a sort of custody arrangement type of scenario. That indicates sort of the value of protecting and not involving the child's information in court proceedings, if at all possible, and also naming what is protected and what is not protected, what parents have access to, what they don't have access to. What they have access to is really all of it, unless, of course, there is information about the other parent. We'll get to that in just a second. And then you can also set sort of what, if you do insist upon subpoenaing me or ordering me to come to court to testify, here are my rates. It is reasonable to lay out a sort of a chunk. So for example, if your clinical rate is, as mine is right now, $150 per hour, you can reasonably say, well, what is 150 times 4? So at least in my area, sort of court is scheduled from 9 to 12, and then from 1 to 5. Those are 3 and 4 hour chunks. And oftentimes there will be multiple cases that will be heard during that 3 hour time slot, but you don't know which one you're going to be called to. And so if you're sitting in the waiting area, that's time you could have been spending with clients. So you can reasonably say, well, so if we're going to say you have to pay me up front $500 for coming to court. If for some reason I'm not there for the full 3 or 4 hours, I will reimburse you for time that was not spent in the waiting area. You can also state that you would require reimbursement for travel, but it has to be done at the very onset of the process, and so it's important to find out kind of what is the custody arrangement at the very beginning, so that you can make clear to the parents kind of what to expect, and define kind of what the legal parameters are before they give consent to participate in working with you. There's also the possibility that if you're working with a minor whose parents are not together, and even if they are, if there is one parent who is requesting information, but you have reason to suspect that disclosing that information to the parent could put the child in danger, then you have the ability to decline the request for their information. Now, a couple things to keep in mind about this. Number one, again, you need to have a very consistent and clear, distinct, concrete system for parents to make requests for protected health information. I have a document that's a template that I've shared with you as an example on Blackboard. And if you do decide to deny a parent's request, if they don't have, if they still maintain legal rights to their child's health information, you need to have a really tight documentation of the rationale for denying the request. The odds are very good that it will be challenged in court, and you want to be sure that all of your I's are dotted and your T's are crossed. Otherwise, you could be forced to disclose. Oftentimes when we are, as clinicians, are denying requests for information, we do have a good reason for it, and we just need to make sure that that reason is well documented, so that there is a very little argument can be made that the information should not be, or that the information should be disclosed. So hopefully that's a little bit be rambling, but hopefully that will be clear enough. So again, when you're talking with couples that want to share things in confidence, name it as sort of potentially detrimental to the therapeutic process, and you will support them in this, working through information that is of a sensitive nature in the service of helping them achieve their therapeutic goals. Similar thing with adolescents. You have a reasonable expectation of privacy, but not a legal expectation of privacy in most cases. If you share something with me during session that I think will be of value for you to work on with your parents, we will talk about that first, and then I will support you as you work through it with your parents. And then, of course, making sure you have very strong informed consent procedures when it comes to identifying who has a reasonable expectation of privacy, what are the procedures for requesting information, what are the criteria for denying requests for information, and if you insist upon summoning me to court, here are the parameters under which I will participate in that system. So look forward to hearing whatever questions you might have in the discussion boards or through other means. So that's a nice segue into sort of what to expect in situations where maybe you are summoned to court. Okay, and if you're working with children, especially those who have separated parents, the odds are probably pretty good that you will be summoned to court in some way, shape, or form. Now, the three ways in which you can be summoned to court are as a fact witness, an expert witness, or as an evaluator of some sort. okay? And I've ordered these again in order of the likelihood that you will encounter these things, right? So when you are, primarily, the reasons that we clinicians are summoned to court are as fact witnesses, right? This could happen when you're working in a family setting, or if you're working with an individual who perhaps has done something or is suspected of breaking the law. And in some ways, this is a great opportunity for you to advocate for your client, but keeping in mind that when you are a fact witness, you are only there to represent your work with the client. You are there to describe what has happened in session, but not necessarily what it means, right? Oftentimes, we can sort of thread the needle with this type of responsibility by talking with the attorney that has filed the subpoena or whatever type of summons it may be, discussing with them the value of having you be in court, and discussing other options such as a summary of the work or just a list of times in which the client was present for session. Oftentimes what is being assessed in a legal proceeding is the client participating in the process. And oftentimes sort of I have been working with this client, here are the times they've come to court, come to session is sufficient, right? In events like this where you think that providing additional details of the work could be advantageous to your client, you may also want to consider having your client or their client's parents sign a release of information waiver so that you can be more forthcoming. But keeping in mind, when you are a fact witness, you are reporting only the facts, just the facts, please, and avoiding sharing your opinion or inferences about what certain things mean, okay? If you do that, you leave yourself vulnerable to having the other side, whether it be the prosecution, the defense, or the representative of a parent who feels aggrieved in some way. You are making yourself vulnerable to a lawsuit of some nature, of some type, that challenges how you represented the facts, and that it puts you in a very gray area. It isn't to say that you would not successfully defend yourself, but it would likely lead to expense and other stress that you, I'm sure, would rather avoid. So, fact witness, just the facts, right? Sometimes we are also called upon to represent the field of counseling and the nature of the profession in court proceedings, okay? So it's important to recognize and to discuss ahead of time with summoning attorneys, how do you intend to use my testimony? Am I being sworn in as a fact witness, or will I be sworn in as an expert witness? It's important to make sure that these things are delineated, right? Because if you are summoned as a fact witness, but then you are asked questions about, well, what is this? What do you think this means? How would you assess sort of progress? Those types of things. That's more in the realm of being an expert witness, because you are representing sort of the concepts of the field, and can also leave you in sort of murky ground, sort of legally and ethically. So, it is possible, though, that you will be summoned as an expert witness to testify about the nature of the work that a clinician might do, right? This is actually a aspect of professional counseling that can be quite lucrative if you have the certifications and training to do so. One of the key ways that professionals get into sort of shaky ground, okay, is, like I mentioned before, you've been summoned as a fact witness, but then you are asked questions that are related to being an expert witness, or even, especially in custody situations, an evaluator. You're asked, like, which, in your opinion, which parent would be the best for this child to live with? That is an evaluator question, and can really set you up for some hardship professionally. And it's very tempting to answer these questions if they are asked, because we want to help, right? And we may have an opinion based on what we know or what has happened in session, but there are so many variables that we cannot account for if we don't have everyone involved. And if we are not providing services from an expert or evaluator position. So, if you are working with a client in a therapeutic sort of scenario, which the vast majority, I would say, a reasonable estimate would be 99.9% of us are performing the service or the profession in a way that is sort of therapeutic in nature and may be valuable as a fact witness, but dicey as an expert or evaluator scenario, then we would do ourselves and our clients a service if we were to respond to questions like this in the following manner. This is paraphrased from the book, The Counselor in the Law by Nancy Wheeler. So if you are sworn in as a fact witness, but you were asked about your opinion, you should say something to the effect of, I am in a therapeutic relationship with my client and not an evaluative one. Therefore, I'm biased, and I cannot provide opinions about the work or what might be good for this client in terms of living situations. The court, to answer those questions, needs either an expert witness or an evaluative witness, an evaluator, and I can provide referrals for clinicians providing that type of service. So the key phrase is, I'm in a therapeutic relationship, not an evaluative one, therefore I'm biased, and my contribution would be compromised because of that. That's a good sort of phrase to have in your back pocket that will help maintain your credibility and integrity as a professional and protect you and your clients from further challenges to your integrity. I'm trying to think of another word to use, but I think that pretty well covers it. So, confidentiality, who can expect it? 3 types of witnesses related to court that you are likely to be called upon to perform if you are providing, especially counseling that involves a minor with parents who are perhaps separated or divorced. And then that takes us into something that's somewhat unrelated, right? And that is sort of whether or not it's advantageous for you professionally to participate in insurance networks. So, most textbooks get at sort of the risks and benefits of this. And for, I would say, the majority of the time that mental health providers have been eligible to participate in health insurance networks, it's been quite controversial, right? There was a time within our lifetimes in which it was not a guarantee that mental health or behavioral health clinicians would be covered. Their work would be covered or reimbursable under most health insurance plans. That changed fundamentally with the passage of the ACA, Affordable Care Act. Sorry about that. Had a bit of just a moment where I went blank. And even then, there's been sort of questions about the feasibility and honestly, the ethics of participating in insurance networks. And some of these are related to just the basic conflicts of interest related to participating in insurance networks. Most insurance plans are run by large corporations that are publicly traded on one or more stock exchanges. And so, depending on your interest in this type of economics or capitalism, you might question whether or not a insurance company's sort of primary loyalty is to their quote-unquote members, which is sort of the people like you and me who perhaps have insurance through their employer, and their employer negotiates a rate with the company, and essentially the employee becomes a member of the insurance network. That's sort of an unintentionally muddled way of putting it, but hopefully you take my point. So is the loyalty to the insurance plan's members, or is it to the insurance company's shareholders, right? I think you will find that there are strong arguments to suggest that insurance companies' loyalty shows up primarily to their shareholders, because the shareholders are interested in the company's bottom line, right? And if the company can keep money in its coffers, they will probably find a reason to do that, right? So that's sort of the basics of the conflict of interest, right? That's one reason why some people choose not to participate in health insurance networks. Another key question that's eliminated in your text is sort of the generally low rates, and it is true. So as a primary example, in my relatively rural area, my out-of-pocket non-insurance rate for an hour-long session with me at the time of this recording is $150. Okay. And that can increase depending on where you live, how much experience you have, level of licensure, those types of things. It is not out of the question for a person with even less training and experience than I have to charge more than $200 in Charlottesville, where there's a higher sort of average income, and it can go even higher if you're in a metropolitan area like Washington, D.C., New York, those types of places, and can really kind of be in stark contrast to what insurance companies are willing to reimburse. So, for example, like I said, my out-of-pocket fee is $150. We'll get into these in just a second, a little bit deeper, but this is a common code, or a CPT code, for a initial session. This is based on Medicaid rates. So you can see that that's already, for our first session, $30 less than what I could charge if I were working exclusively with out-of-pocket private pay clients. And then this code here is the most commonly used sort of session for an individual 53-minute to 60-minute duration session. And this is also based on the Medicaid rate, at least in my home state of Virginia. And you can see it's already $50 less than what I could command if I were only working with out-of-pocket private pay clients. So yes, the rates are typically lower, and that's something you would want to take into account as you're sorting through whether or not you want to participate in insurance networks. Also, especially when it comes to providing family counseling. Okay, so this might be a good time to talk about CPT codes. So CPT codes, and I'm blanking at the moment on what CPT stands for, but essentially these are a series of codes, a series of numerical identifiers that were established by HIPAA when it was passed in 1996. Established by HIPAA that described different medical procedures, okay? And so think about this, every medical procedure known to the medical profession and healthy professions has a number like this, okay? And the primary ones that we use in mental health are 90791 for an initial diagnostic consultation. There is this is 90834, that's for a 45-minute session, a length of session with an individual client. There's also 90832, which is a 30-minute session. And then 90837 is the typical hour-long session with an individual client, okay? 90846 and 90847 are specific to conjoint family or couples counseling, right? And as you can see, 90847, this is a session with multiple people in the room, a family or couple session. And you can already tell that just based on the Medicaid rates, it's already less than a typical individual session, right? And 90846 is a family session without the identified client present. So if you're working with an adolescent and you have a parents-only session, this is the code you would use to bill or send a claim to the insurance company. And you can see that it's already even less than what the 90847 is, and of course much less than 90837. So again, yes, the rates are lower, something that you should take into account for sure. And then of course, there's been chronic complaints about the hassle of working with insurance companies. And I can confirm that this can be quite difficult, although I will say that it has been made much, much simpler and much more streamlined with the advent of electronic health record and practice management software, such as, well, there are lots of different companies providing this. I should be careful not to promote any single one as a professor, but I can say that I've used EHR software and web-based formats in my practice, and they make the hassle of filing claims, which are very specific and drawn out forms that need to be completed. Oftentimes medical practices or mental health practices would have a staff member, a non-clinical staff member that was specifically dedicated to providing sort of insurance billing sort of tasks. Now, those types of employment opportunities still exist, especially for larger practices. But for those folks who are doing private practice and it's just them doing the work, EHR software has streamlined this process and made the hassle a little bit less of a headache. Now, that doesn't mean that it's completely headache-free, right? So, getting back to the conflict of interest, I can provide an example here recently where I was in transition between working as a full-time clinician in network with a number of insurance companies to moving into higher education and academia, and kind of flipping. I was doing adjunct work in higher ed and primarily making income via clinical work, and now I flipped that, right? And so I opened a private practice, and for most of the insurance companies that I was participating with, the transition between my network status and my new practice was relatively seamless, right? I had very few problems with it. But there was one company that will remain nameless that for some reason, and I can't identify quite what it was, but my transition between my network status, my provider information, and my new practice did not go well at all. In fact, it went more than a year between the time in which I left my old practice and the time in which I was sort of considered in network in my new practice. And that put the care of my clients sort of up in the air a little bit, and also had a financial impact upon me. Because I was put in the position of, do I provide care for my clients, or do I take the risk of sort of eating the money that I'm could potentially be making without sort of having, as I kind of sorted out this limbo experience, right? So that is one example of how sometimes the system does not work smoothly. It does create a hassle. It can have an impact on both your clients and you professionally and financially. So keep those things in mind. Now, that's sort of the dark side of health insurance, especially as it relates to family practice. The upside, I would say, are that participating in insurance networks improves client access to services, because most people these days, the vast majority of people these days, participate in some type of health insurance network, okay, or plan, whether it be through an employer, through a government-sponsored marketplace, or through Medicare or Medicaid. Of course, Medicare and Medicaid, as you're familiar with, I would imagine, are government-sponsored health insurance plans for people that would typically have some type of hardship, whether it be they're living in poverty, or they have some type of maybe disability that prevents them from working and earning an income. And so these are sort of ways in which government provides funding for services that otherwise would not be able to have access to. So participating in insurance networks does improve client access, because they have a wider range of people that they can see for a reduced cost, right? Because as we've talked about, like if I'm charging $150 for just direct pay, if I'm seeing a client that participates in an insurance network, they might have a copay that's much less, usually $25 to $30. The highest I've seen is $60 for a copay, and in some cases they may not have a copay at all, may be completely covered by their insurance company. So that improves access because it eases the burden upon the clients themselves. You also have the improved odds, depending on where you live, for regular reimbursement. Okay, so there have been chronic complaints for many years about how slow people, how insurance companies reimburse, how there may be sort of disputes about what is reimbursed. I can say from my experience that regular reimbursement has been a feature of my participation in insurance networks. Rarely, if ever, have claims been denied. And if they have been denied, there has been at least some way of sort of mitigating or addressing the issue. So these are some of the reasons to participate. So client access, regular reimbursement, EHR software. I should get at this too. Like, this is an interesting, I think, opportunity for advocacy for those of us who are interested in and have sort of a affinity for systemic-based work. Obviously, just based on the numbers here, the medical and insurance systems don't place as high a value on family work as they do individual work. I think that there's an argument to suggest that that's upside down, especially when we're working with minors, because when we're working with someone on their mental health issues, there's usually some type of systemic or pattern that is leading to and maintaining the problem that we're trying to address. And unless you have multiple people working with that child in a wider range of settings, primarily at home, you run the risk of undermining their success, because they can have success in your room, but if they can't generalize it to their home or their school or their community, and they don't have your support there, because I don't know about you, but my clients don't take me home with them, then essentially what I'm getting at is that there's arguments to suggest that the family work should be of higher value than even the individual work. So perhaps an opportunity for advocacy. That being said, even with these rates, and keep in mind these are Medicaid rates, which are understood to be some of the lowest in the profession, even if you're seeing a full-time caseload of family work at the $85 reimbursement rate, and full-time generally is considered 25 hours a week, right? 25 sessions a week. So if you do the math there, 25 sessions a week over, let's say 50 weeks will allow you 2 weeks of vacation. You're still grossing more than $100,000 in that year, right? Now, of course, that gross amount does not account for overhead, right? So whether you're maybe paying for office space, and this, of course, assuming private practice, you're still going to make a decent living providing family care at full-time rates, even at that low base rate. So, downsides are there are lower reimbursement rates for participating in insurance networks. There is a conflict of interest between whether or not the insurance company wants to reimburse you for the service you provide, or if they want to keep the money in their coffers. And there is well-established hassle for participating in these networks. There's also the upside of client access, the odds improve for regular reimbursement, and the process has been simplified in many ways, and the hassles have been mitigated by the advent of electronic health network software. And so you make the decision about how you want to approach your practice with these 3 key professional issues in mind, right? There are nuances of maintaining confidentiality. There are key issues to be aware of when it comes to our responsibilities when we're summoned to court. And there are key issues to keep in mind when we're deciding about how we want to be reimbursed for our work. I look forward to questions, comments, concerns that you may raise in the discussion board or other means, email, phone call, whatever the case may be. Otherwise, I think that pretty well handles what I wanted to make sure we covered in terms of professional issues. And I look forward to seeing you back here for videos about solution-focused and other constructivist approaches to systemic work. Thanks.